Welcome to Transnational Competition Law course. And today's lecture of mine is going to be devoted to the theories and principles of extraterritorial application of competition law. Or you can say, in other words, under the course of transnational competition law, we have to come directly that what is meant by transnational competition law, the ambit, scope, and purview, nature, and content of the transnational competition law. And to begin with, dear learner, we have to understand theories and principles of extraterritorial application of competition law. And today's lecture on theories and principles of extraterritorial application of competition law will be dealing with the construction of extraterritoriality in competition law, doctrinal foundations of extraterritoriality, public-private law dichotomy of competition law vis-a-vis the conflict of laws and the application of public law discourse under the competition law. Then we will be examining the principles, the theories of extraterritorial application. We will be devoting to the nature, extent, and application of territorial principle, protective principles, universal jurisdiction principle, active personality principles, passive personality principles, and territorial effect doctrine and principle of extraterritorial application of competition law. Then we will be switching to the doctrinal legacy of the Lotus case in reference to prescriptive jurisdiction, adjudicative jurisdiction, and enforcement jurisdiction to enforce competition law in abroad. And finally, having discussed all these dimensions, we will be examining in depth the legality and legitimacy of extraterritorial application of competition law and will be reaching to a conclusion that what can be said and what can be done to transform to a new approach to extraterritorial application of competition law. So, dear learner and viewer, we will begin with the very construction of extraterritoriality in competition law. Dear learner, we will be first dealing with extra construction of territoriality in competition law. The construction of extraterritoriality in competition law transcends the boundary of sovereignty and challenges territoriality as a conceptual basis, especially in the circumstances of liberalization, privatization, and globalization. The interrelationship of the territory and power in the age of globalization has a critical and complicated understanding. The emerging model of jurisdictional theories are moving away from power, territory, and territoriality to a universal jurisdictionalism in matters of competition law. The basis of defining any legislative authority in the domain of competition law rejects the salience of territoriality to jurisdictional framework. While territorial contacts may function as simple, factual, and jurisdictional analysis, the territoriality and extraterritoriality are legal construct and the legal claims made by competition institution within particular legal system. The meaning of extraterritoriality in the, the meaning of extraterritoriality in US and German competition law or UK competition law or European Union competition law or Asian competition law or the Pacific competition law will not be the same in the transition from traditional conflict models to the newer regulatory strategies. Moreover, the process of integrating critical reconceptualization of territory in the jurisdictional theories essentially reflect dualistic and monistic legal regime in the Hans-Kelson's framework. This is juxtaposed to foundation of traditional and modern jurisdictional law, coextensive with and indeed incidental to state sovereignty. The connection between the jurisdiction and sovereignty is inevitable in the metaphors of power and almost platitudinous, as Lord Macmillan has observed, that it is an essential attribute of sovereignty as all sovereign independent state should possess jurisdiction over all persons and things within its territorial limits in matters of civil and criminal arising from its own jurisdictional boundaries. This passage of Lord Macmillan captures a triangular relationship of three concepts: territory, sovereignty, and jurisdiction. So the trilogy of territory, sovereignty, and jurisdiction in fact lacks functionality of territory-based jurisdictional theories. It also paves the way for re-theorizing the relationship between territory and jurisdictional authority in the age of globalization. Thus, our engagement of re-theorizing of extraterritorial application of competition law in the context of principles and theories connects to international relation theories and theorists who have challenged the continuing viability of the Westphalian model of sovereignty. Their proposition seems to be the fact that the sovereignty, primarily as an exclusive control over particular territory, fails accurately to capture the source and extent of government's power. with these construction and deconstruction of extraterritoriality in competition law, we will try to understand that what are the doctrinal foundations of extraterritoriality. The doctrinal foundation of extraterritoriality under competition law can be extrapolated within the jurisdiction of United States and Germany in the light of having some contrasting and some overwhelming laws and policy. In this context, dear learner and viewer, neither Sherman Act contains provision for extraterritoriality, nor Clayton Act refers to cross-border competition. The United Nations law regulative legislative jurisdiction hence developed almost exclusively in judicial decisions, as the relevant institutes are silent on the question of the scope of extraterritoriality. The Sherman Act does not contain a provision specifically addressing its jurisdictional reach in cases of cross-border elements. Similarly, Clayton Act, which authorizes private lawsuits based on violations of antitrust law, refer back to the Sherman Act for jurisdictional purposes. It is only the Foreign Trade Antitrust Improvement Act of 1982 of the United States, which adopts extraterritoriality in matters of only export trade from United States and not for any kind of antitrust violation. In this context, we have to refer to Justice Holmes' decision in American Banana Company versus United Fruit Company 1909, which becomes very germane in the context of antitrust law and extraterritoriality as it has been underpinned in the judgment. It says that law is a statement of the circumstances in which the public force will be brought to bear upon men through the courts, the construction of any statutes as intended to be confined in its operation and effect to the territorial limits over which the lawmaker has a general and legitimate power. The general and the universal rule is that the character of an act as lawful or unlawful must be determined wholly by the law of the country where the act is done. The American Banana case of 1909 is followed by United States versus Aluminum Company of America 1945 decision, wherein the Court of Final Appeal adopted a more expansive view of territoriality. Justice Hand stated that it is a settled law that any state may impose liabilities even upon person not within its allegiance for conduct outside its boundaries that has consequences within its border, which the state reprehends. and these liabilities other state will ordinarily recognize. The legislative prescription of Sherman Act and the Clayton Act of the US transpired German Competition Statute, named as Law Against Restraint on Competition, and had been applied to all restraint of competition having an effect within the territorial scope of this act, even if they are caused outside territorial scope of this act. The provision expresses the legislative intent, intent to adopt anti-competitive effects within Germany as a sufficient basis for prescriptive jurisdiction, indeed to adopt effects as the only acceptable basis for jurisdiction. The modern German competition law, therefore, begins approximately where the Aluminum Company of United States begins in the US system. Thereby, the foundational studies of the German law on international competition by the writer like Ivo Schwarz and Eckhard Rehinder recognized some limits would be necessary in order to prevent insignificant effect from triggering the application of German law. The competition law do not provide rules allowing its court to apply foreign competition law or rules to choose a forum in cases involving foreign element. Similarly, there is no convention at the international level which governs conflict of competition law rules. Under this backdrop, we have to refer to Article 2, Subclause 2, Subclause H of the Hague Convention on the Choice of Court Agreement 2005, which specifically lays down that it does not apply to antitrust and the competition law matters. In such a situation, we have to then look the public law, private law, and the conflict of law dichotomy of the competition law. It is generally said that the competition law combines the characteristics of public law and private law. The public law stance is very clear from the duty not to abuse a dominant behavior, the duty not to enter into an anti-competitive agreement, the duty not to comply with the merger notifications requirement, and the duty not to engage in unfair trade practices. In most jurisdictions, the public law character of competition law is evident in the use of criminal, institutional, administrative, and punitive sanctions. Although competition law has many public law characteristics, competition law in some jurisdiction has private law characteristics as well. This can be buttressed by the example of Canada and US. In Canada and US, private parties can make civil claims for damages relating to violation of competition law. The difference between extraterritorial application of competition law and conflict of laws hinges upon their relation to public and private law, and conflict of law relates to only private law that regulates private relationship, while extraterritorial application of competition law relates to public law, and thus competition law typically provide an extraterritoriality principles out of the limited framework of public law discourse, private law discourse, and the conflict of law discourse.